Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. This week's webinar addresses a common concern shared by many aging families. When you're no longer residing there, will your kids get the house? It seems like such a simple question and answer, but of course, there's a catch. Today, Bob will explain the do's and do nots of passing your home to your children. But before we get started, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have a general question during today's presentation, we encourage you to use the chat box. We will save time to review questions during the webinar, and if for some reason we don't get to your question, we will contact you after the presentation. Lastly, note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share it with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is a nationally board certified elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He's currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, my favorite reason, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. This is a good topic today, and I want to kind of restate the tagline here. A lot of what we're going to be talking about is how your kids will not end up with your house. So we're going to talk about a lot of the pitfalls about what people think they've got it all set, they got everything all set, and it turns out that the kids don't get the house, or if they do, they get it in a much more complicated manner than the parents had expected. So we're going to kind of do the opposite. Okay, well, the kids get the house. Well, we're going to go through all the ways that it can go wrong, and we'll go through some of the ways that it can go right. So let's dive right into this here. And so the first question is, well, a lot of people have this question. Well, what happens to my house if I have no will? And this can go either way, to the extent that there are lots of folks out there that just assume the kids will get the house, and whether they have a will or not, whether they just don't realize that there's any issue. Of course, the kids are going to get the house, and we get this all the time. Kids will call up and they say, well, I just need a deed. My dad died, and I need a deed to put the house in my name. It doesn't work that way. You got to go through the process now. Probably going to end up going through probate for that to happen. So the first question that people have is they assume that, sometimes people will assume that they don't need a will, or they don't need any type of deeds or mechanism to transfer the house, that it just automatically goes to the kids or automatically goes to the spouse upon death. And that is not the case. The other is sort of the other extreme. Some people will believe that if you don't have a will, everything's just going to go to the state, and that's not true either. So what are the pitfalls of not having a will? Well, the first thing is the state of Michigan has written a will for you, okay? And so will it end up going the way that you expect it to go? And the answer is maybe and maybe not. This is particularly difficult when we have a blended family. His kids and her kids, or not all the children are from the same relationship. And so what people just assume is they say, okay, well, it's going to go to my spouse, and then it's going to go to my kids. Well, particularly if you don't have a will, that's absolutely not the case. What would happen with no will is that in the event that you die first and it goes to your spouse, let's just say that happens, that either by will or by just having a joint owner on the property, that the house goes to your surviving spouse. Well, then is it going to go, let's say each of you have 2 kids. So there's 4 kids altogether. Wife has 2 kids, husband has 2 kids, and husband dies first. And so let's assume that the wife now owns the property, whether it be because she owned it prior to his death or whatever the scenario is. Who's going to get that house, or who's going to get the value of that house after wife dies? And the answer is wife's kids. It doesn't matter what husband intended or what even husband's will says. One of the things that we frequently see is that there's an expectation of what's going to happen to the house, but it's never documented, it's never written down properly, there's no process. And people just make this assumption that they get the house when that's not the case. So let's just say it's a slightly different scenario. Let's say mom and dad bought the house together in 1970, and they only have kids between each other, so they got 2 kids, and they've been married forever, and no kids outside of that relationship, and no second marriages or anything like that. And then dad dies, and since they bought the house together, the house automatically goes to mom. And then mom dies. What's going to happen? Does the house automatically go to the kids? Well, it will ultimately go to the kids after we go through this probate process, okay? So they call it the decedent's estate in probate. It's going to take a minimum of 5 months, but typically about a year to go through that process. And that is not automatic. So when people call us up, the kids call us up and say, my dad died, I need to get the house in my name. Can I just come by and we can sign off on that? Nope, doesn't work that way. We're going to have to go through this whole court process. Typically, it takes close to a year, or around a year, to go through that court process. Like I said, it can be done as quickly as 5 months. It just usually isn't. Usually, it ends up dragging on a bit. All right, so then, of course, the next one, is, well, what if I have a will? Does that solve the problem? And the answer is, actually, it's often very similar to the situation of no will. Because remember, the state of Michigan writes a will for you. If you don't write a will, then they just make assumptions about what you would have wanted. And sometimes those assumptions are very, very wrong. But the issue is it still goes through probate. So one of the things that people assume is, well, my kids get my house, is they assume, well, when I die, the kids will get the house. No, it has to go through a probate process first. But those same things apply that we talked about with no will, in that this is particularly difficult and challenging in the event of it's a second marriage, or there's his kids and her kids. What happens if we have a will and husband has a will and wife has a will, and they don't say the same thing? A lot of times when husband and wife have wills, they call them sweetheart wills. In other words, they say, leave everything to my sweetheart and then equally to the kids. That's what we call a sweetheart will, meaning that everything goes to the spouse and then goes to the kids equally. And many people have those wills, but I've had lots of folks come in where husband has a will and he leaves it in one direction, and wife has a will and she leaves it in a different direction. Sometimes it's because of different children, or sometimes because it's different preferences as to who gets it, or they want to leave some to charity, or they want to leave it to their sister or brother, but they don't have a meeting of the minds or a joint agreement as to how it's going to go. Well, then what's going to happen with those assets? Well, typically what's going to happen is one of you is going to die first, right? One of you is going to die first, and most of the time, or often, they leave all of the assets to the surviving spouse. So then the surviving spouse's will is the one that's going to be binding. It still has to go through probate court, still has to go through that process. It's going to take, 6 months to a year, 5 months to a year. But the most important part of that is that if husband's will and wife's will aren't the same, husband's wishes are not followed because he had the misfortune of dying first. In other words, we're kind of rolling the dice, and I hear people do this all the time, and they say, well, and I know that they're thinking that somehow that both wills will be honored in some way, or that, half of it would go according to husband's will and half of it will go according to wife's will. No, it won't work that way, because the husband's will, if he died 2 years earlier or 60 days earlier or 10 years earlier or whatever, and everything went to the wife, now the wife's will decide that. This also comes about particularly when we have a blended family, meaning his kids and her kids. because the surviving spouse can change their will. So often if we do a will, we'll say, okay, no, we got to come to a meeting of the minds. We got to say what happens after one of you dies, and we got to say what happens after both of you die. And if we want to do different percentages, and 60% goes to your kids, and 40% goes to your kids, or however we want to do that, but we got to have this meeting of the minds where we all kind of agree on this, right? And so that it's not just a roll of the dice of whoever dies last wins, so their kids win. And so the issue here, of course, is with the house, often the house is going to be jointly owned. And if it is, then the first person who dies, their will has no impact on it. That means the second person can change their will. And they can say, and I see this all the time, surviving spouse says, you know what, I know my husband wanted to leave some of this to his kids, or my wife wanted to leave some of it to her kids, but they haven't been around much since their dad died or since their mom died. They don't visit me at Christmas anymore. I'm just going to leave everything to my kids, even though maybe both sides put in an equal amount, or even maybe one put in more than the other. But the bottom line is this is a frequent thing that you can change your will, and so the surviving spouse changes their will. So then maybe your kids don't get the asset. This is always typically the case, and there has been some things that lawyers have tried to come up with that honestly just muddied the waters. So sometimes we'll have a joint non-revocable will, which is, I view as most of the time just a really big mistake, or an agreement not to amend our wills. Again, I find this most of the time to be a huge mistake, causes all types of ancillary problems, even from the standpoint of, well, what if one of you gets sick and we need that money for long-term care, or we want to preserve that money from the cost of nursing homes? All of this comes about when we have these handcuffs on that, in our 40s or 50s, we sign a document that we can't alter or amend or adapt to our needs as we get older over the next 50 years. That to me is lawyers that are over planning and not living in the real world. They're just living in a law textbook. Okay, so I really don't think we should have a non-revocable will or a joint will or a agreement not to amend our wills. I think all of those are just bad solutions. Okay, so that's the issue with a will. Sometimes it's going to go to your kids, sometimes it's not. The other thing with a will is a will always goes through probate. We've talked about this, right? A will, if you need to see the will to see where something goes, if we're having the house go through the will, then it is going to go through that probate process, all right? And in probate process, we have things like spousal rights and we have family allowances. And so sometimes if the house is the only asset, it can be eaten up or at least deteriorated by the spousal rights under probate, or the family allowances under probate, which could go against your terms if you had made other arrangements so that your spouse wasn't going to receive a portion of the house or wasn't going to receive a portion of your estate. You have separate estates. Well, through a will, the spouse always has the right to elect against the will. The family has the possibility of family allowances, which could ruin your intent, that the probate court can kind of go against what you had intended because there's these standard rules that the court follows for a spouse or children that they can claim allowances. Okay, and maybe sometimes that means the house has to be sold rather than given to the person that we wanted it to go to. So is probate bad? Is probate court a bad thing? Is it a necessary thing? Different lawyers are going to have different perspectives on this. All right, and I'm not going to say that there's only one right answer. And that's one of the things that is enjoyable about the law for me, is that often there are many answers. There are many right answers. I had an opportunity, someone just reminded me of this recently. I had an opportunity to be a moderator at a half-day event of some experienced lawyers, and we were discussing a topic and we were discussing a fact pattern and seeing how people would resolve the issues and get their clients the help that they need, or these hypothetical clients the help that they need. And I was able to be the moderator, and I kind of went from table to table to see how people would resolve it, and there was probably 10 tables and we had 10 different solutions, and I found that fascinating. So there are different ways to accomplish this, and every lawyer probably has their own biases and perspective, and I'll readily admit my bias. My bias is if we can keep it out of the court system, in most cases we're going to be it's going to be better and cheaper and faster and quicker and less frustrating and less annoying and less anxiousness about settling the estate, because many times we don't need it to have to go through probate, as long as we've got competent and trustworthy, honest children that or heirs, even if it's not your children, who would be able, that we give them sufficient authority and sufficient direction that we can resolve this without having to go through the probate process. So it's not typically necessary. Is it bad? Well, I'll leave that up for you to decide. A lot of lawyers like the idea of it because there's a process, there's deadlines, there's dates, you know, and I have seen people that avoided probate, and the person they appointed to be in charge, their executor or trustee, didn't settle the estate, sat on it for a year, 2 years, 3 years, 5 years, and just didn't follow a timeline and didn't settle the estate. Well, once you open up a probate estate, the court's not going to allow you just to sit on it without action. At some point, they'll issue a bench warrant and say, you better show up in court and tell us why you're not moving this case forward. So there are some advantages of probate, especially if we feel like the person that we're appointing to be in charge is going to need that structure and timeline. But all things being equal, for most families, I think it would be better to stay out of court and look at those options, especially for the house. Okay, so the next thing I want to talk about is something about how people often will think, okay, my house is definitely going to my kids because I'm not worried about the fact that I don't have a will. I'm not worried about that I have a will. I'm not worried about probate at all. And the reason is because I paid darn good money to a lawyer, and a lawyer drafted a trust for me, sometimes called a revocable living trust. And so now I know my house is going to go to my kids because I have a revocable trust. Is that true? I'm going to tell you a lot of times. So one of the things I'll often say in classes that I teach is that most of the time, or much of the time, trusts don't work. Now, I said that, and yet I'm also often recommending trusts. Why would I be recommending something that I say doesn't work? Because it only works if you know how to work it. It only works if you do it right, all right? And so a lot of people would love to blame the lawyer on this. And honestly, the lawyers can take some blame by not educating their clients and making sure their clients understand how a trust works versus how a will works. And I think there's probably a real deficiency in the industry among lawyers of not making sure our clients understand what the legal documents they have do and how to make sure that they're going to work properly. Because the issue isn't that it wasn't written right. It is not. The problem's not that the lawyer, when he sat at his keyboard, didn't type it right. That's not the problem. So frequently people will come to me and say, well, can I show you my trust and see if it's going to work? And the answer is no, I can't. As it relates to the house, I would need to see the trust and the deed to the house. So the deed to the house should name the trust. And if I see the deed to the house and it doesn't say anything about a trust on there, then guess what? That trust is not going to work from the standpoint of keeping that house out of probate. So I thought this was an interesting graphic. The little seesaws from, remember when we were kids? I don't think they allow these anymore in playgrounds, but so I'm probably dating myself a little bit. But when I was a kid, they had these seesaws, and you'd get on one end and you'd go up and down and all of that. And so for in this example, we have the will-centered plan, which we know goes through probate. It's saying, well, it's a little easier to set up now. So the effort's not now, the effort is later. Okay, so we're going to have to put in a lot more work later after you're deceased. It's going to cost a lot more money typically later. Because we're creating a probate-based plan, a will-based plan. And so the leverage part of it is it's a little easier to set up now, cost less now, but it'll be a lot more costly later and a lot more effort by your family and a lot more red tape and process and things like that. On the other end of the spectrum, we have what we call the funded trust. The words that we started using in our office is that the assets are aligned properly with the trust. But by funding the trust, it just means that the assets are titled properly, but the beneficiary designations are titled properly, and they recognize the trust. So typically in a situation like this, with some assets, we will retitle the asset. So let's say it's your house. So your house, and your name is Jane and Dave Smith. So now you bought this house together, and the house is titled to Jane and Dave Smith. What would we do if we have a trust? Well, now we're going to have a new deed. We have to prepare a new deed and file that deed that says this house is owned by Jane and Dave Smith as trustees of the Jane and Dave Smith Trust. Okay, so I can tell you if the house is going to work as it relates to, I have to see the deed, I'd have to see the trust, and that's what we would call a funded trust or asset aligned trust, meaning that the house is in the trust and the house will follow the terms of the trust. What's the problem with that? And why do I say it's not always the lawyer's fault? And the issue is that most people will go and they'll go to their lawyer and they have a house, and maybe the lawyer will even, sometimes the lawyer puts it in the trust, sometimes they don't. But let's say the lawyer even did put it in the trust and filed that deed for you and took care of all of that. And what happens 10 years later? Well, your last child moves out of the house, or you get tired of mowing the 2-acre lawn or whatever it is, and you decide, you know what, it's time, we're going to move into a condo so it just has easier maintenance, or we're going to move closer to the kids. And so you sell that house and buy a condo. You sell that house and buy a new house in another state, or in a closer to the kids, or just more appropriate size for you. Is that new house going to go to the kids? Not in the way that you expected it to. Okay, so you've spent good money on a trust. You had the house at the time, maybe the house was even in the trust, but you sell that house and get a new house or a new condo. That house is now not going to follow the terms of the trust, so it's going to go through that probate process. And then is it going to follow, is it going to get to the kids? Well, maybe it's going to get to the kids, maybe not, depends on that probate process. But secondly, it's definitely going to be not the process that you expected when you paid good money to get that trust drafted. So you got to understand, once you get a trust, it's not just you put it on the shelf. You got the trust, you just put it on the shelf and you never have to look at it again. No, if you buy new property, you have to get it and look at it again. If you open up a new bank account, you have to look at it again. And so you have to have an understanding. This is why we do constant trainings for our clients. This is why we do the webinar Wednesday. This is why we have annual meetings for our clients. This is why we have trainings for the children of our clients, so that they know what to do when it's their time to step in, either because mom and dad died or because they're incapacitated. To me, the worst case scenario is the middle section here. So now we have this unfunded trust in the middle. So now we're on the seesaw, and you see the work is now and later. So how much work do we have to put in? Well, we have to put in work now and later. So we're doing all the effort of getting the trust drafted and paying the money for the trust, and it's not funded or the assets aren't aligned properly. Guess what? Now we have to do both. We have to go through, we did all the effort of getting the trust in place, but now we still have to go through probate because the trust wasn't funded. The house wasn't put in the trust. We sold the house and bought a new house and didn't put the new house in the trust. And this is so now we've increased the cost and increased the aggravation of that because we didn't understand how the trust worked, or we forgot, or we didn't have a process for making sure that the new house gets in there. This is why our office has spent a lot of time on this process and making sure that our clients know that they should get a hold of us and that we're a resource, and when things change, they got to get a hold of us. And then we send out reminders. That's why we have our annual meeting, to make sure that people remember that these are the things that need to be done. That's why we train the kids. We do education for the kids so that they know and they can remind mom and dad, and they can take care of it, before mom and dad pass, or they can do it after they pass, whatever. But the bottom line, that they know that there's a process, and it's not an overly complicated process. to put that house in the trust, that new condo in the trust, it's something that we can give the information to your realtor and the title company, and they can just do it at the time that you buy it, and it doesn't cost anything extra. A lot of people forget about that, and then they'll say, "Oh my goodness, I could have done this for free if I would have called Mannor Law Group before the closing date on that new house, and they would have just put it in the trust. But now I forgot to do that. Well, what do we do?" Not a problem. We can still fix it. We can still put the new condo in the trust. Costs a couple $100 or something like that, but it's, we'll be happy to help you do it for free. But if you forget and you don't follow those, and you wait until afterward, there'll be a small fee to make sure that. But again, none of this is overly complicated. You just have to make sure that you do that, and that's why we have those constant reminders for our clients. So some people will say, "Okay, well, wait a second. That all sounds complicated, Bob. I want a simple answer." I have this graphic posted on my social media that shows all the lines of people, and one line of people are going in this direction and falling off the cliff, and the other line of people are having to take this hill and take a much more tough path, but they're getting to the destination, right? And so what they're basically getting at is, there's easy answers that lead to you falling off a cliff, and there's more difficult answers that lead to you getting what you want. And so the easy answers are often not the best answer. And so people will often say, "Well, I should do a ladybird deed. I should do a quitclaim deed." And often those are actually bad answers. And I know there's lots of attorneys. Typically, attorneys aren't just doing quitclaim deeds, adding kids' names to property, although that used to be a very popular thing, and it causes all kinds of trouble, which I'll tell you about what kind of trouble it causes. But also, ladybird deeds now have become very popular. So instead of just adding the kids' names to the property during mom and dad's lifetime, they're doing these ladybird deeds, and they also have lots of problems. And these are often reasons why the house won't go to your kids, is because a ladybird deed is drafted 20 years earlier, a quitclaim deed is drafted 20 years earlier. That one piece of paper, that document, doesn't have any ability to adapt to what happened over that 20-year period, okay? So there's all kinds of problems that these things create. I was on the phone with another lawyer recently, and they're going to be basically an opposing party because what happened is, and it was a deed that we did not draft, but we're helping the family after the fact, and we did not draft this deed because we would not draft this deed, but they used a ladybird deed. And so the mom, or the decedent, had done a ladybird deed, and she said, "Well, I don't want to have a trust, and I don't want to pay for a trust, and I don't want it to go through probate, so I'm going to do this ladybird deed that says that when I die, it's going to go to," I had 3 kids, one of them has died, but I want their family to get a share, so I'm going to have the ladybird deed go to my 2 kids, and then my deceased child's 2 children. In unequal shares. In other words, the deceased child, the grandchildren were going to get a 1/6, and each of the children were going to get 1/3. And so now the son comes to us and says, "Okay, I thought this was going to be simple. I was told this was going to be simple. Now, that we avoid probate, we do all of these things, but now here's what the problem is. Between the time that the parent drafted that deed, one of the other 2 kids died. Okay, so now 1/3 of the house we've got a problem with, because how do we resolve that? Does everybody else's share get bigger? Are we deleting that family where we didn't? Clearly mom wanted each family to get 1/3 of it, but now one of them died. So what happens now? Well, the deed can't tell us that. And so probably that's going to go through probate, and we're going to have to get instructions from probate to say what happened to that 1/3. But it's worse than that, because now we've got grandkids involved, and we've got a child involved, and they can't agree on, so the son and the grandkids can't agree on whether we should sell it, what price we should sell it for, whether or not one of them can just live in it for the time being without paying rent, even if it is rent, how much is the rent? What offer would we accept if we ever do get around to selling it? Are there any liens against the property? All of these things there's a dispute about. So when I talked to the other attorney, he said, oh yeah, pretty much whenever it's a ladybird deed or a quitclaim deed, I just automatically file for partition. So partition is going to court. It's not, it's going to court to say, okay, because mom thought she was doing something smart by signing this quitclaim deed or ladybird deed, it's in his mind, it's almost guaranteed we're going to end up in court. So the judge decides how we're going to divide this up. That's what a partition action is when it comes to real estate. And he kind of implied that, yeah, a good portion of the time when mom or dad signed a ladybird deed or a quitclaim deed, that we end up in court because we're just going to say, okay, we're not going to let this linger. We're not going to let this go. We're just going to end up in court and let a court decide, let a judge decide in a partition action. And it didn't surprise me a bit that that was his perspective on it, because the reality is, I think a good portion of the time, it results in bad results. There's so many examples I'm going to give you here, and I'm going to try to limit this to a reasonable number of examples, but I could probably come up with 20 of them as to why ladybird deeds and quitclaim deeds are not a great estate planning option. We have to use them from time to time. So we use quitclaim deeds to transfer the house into the trust. So that I said earlier about the trust. So that's okay to use a quitclaim deed as long as we're using it not to add kids' names, but to put it into the trust. Ladybird deed, sometimes the same thing, but even that I question as to whether that's the best plan most of the time. We definitely use ladybird deeds in the context of Medicaid. If we're applying for Medicaid, we're probably going to use a ladybird deed. So there are some contexts in which both ladybird deeds and quitclaim deeds are definitely going to be recommended by my office, but they're used too loosely. They're used without nuance or somebody thinking through, well, what's going to happen when I die, kind of a thing. Are the kids really going to get my house? So let me give you a couple other examples of this. So I mentioned earlier about, well, what if one of the people die? What if, you list your 3 kids and one of the kids dies before you? Well, what happens to that 1/3 share? And there's ways to draft the legal documents to say whether it would go to the two remaining kids or whether it would go to the survivors, the grandkids of the one that died. But there's a real question as to whether that's going to be accepted by the title company. So I think there's a good chance that the title company is still going to want guidance from the probate court when people did not die in the right order because of the nature of property ownership. And they'll say, okay, I know what you intended, but the court has to tell us whether that's legal or not. And title companies will often do that if we end up having a ladybird deed that says that where one of the people on there died before the parents died. And so then the other issue is with the ladybird deed is that what I frequently see is it'll say from mom and dad to the kids upon our deaths. Well, I think that's almost always a bad idea when the ladybird deed says from mom and dad to the kids upon our deaths. Why? Because one of the reasons why people thought that they were doing that was because they thought that that's going to protect the house in case mom or dad goes into a nursing home. But that actually often has a negative effect on that. Because what happens often is, let's say we have mom and dad and mom goes into the nursing home, but dad dies first. Well, what good did the ladybird deed do? Because the ladybird deed basically transfers the asset upon death. But if we have both mom and dad on there, and mom is the one that needs Medicaid, and dad is the one that was living in the house, and then dad dies, well, what does that mean? Well, it means mom's now the sole owner of that house, and if we sell it, that money is going to go to the nursing home. That's not going to protect us from the nursing home. So we use ladybird deeds, but not typically with a married couple. We're going to want to transfer it to the one that is not on Medicaid and then do a ladybird deed. But often we end up with the situation where a ladybird deed causes all kinds of trouble, with regard to when it comes to nursing home and things like that. Can we protect your house from the nursing home? Are there legal ways that are going to follow a clear path to protect the house from the nursing home? And the answer is absolutely yes. There are ways around what we call estate recovery. Now, what we need is the person that owns the house either to have the ability to sign legal documents still, or secondly, have appointed somebody who would be able to sign a ladybird deed. Now, sometimes that you would think that, well, if they have a power of attorney, right, that would be sufficient, power of attorney. Well, it depends on what the power of attorney says. So a lot of power of attorneys will not allow the person to sign a ladybird deed. So we need to make sure that language is in the power of attorney, sometimes something we call extraordinary powers when it comes to those legal documents. The bottom line here is this is often something that people think that they want to do as a self-help approach. They're going to download a document. They're going to download a ladybird deed. They're going to download a deed. They're going to go to Office Depot and get a form that they can fill out. And the problem with that is there's more nuance here. We can easily get the results that we want. We can make sure the kids are going to get the house and they're going to get it in the right way. But there's so many ways to mess this up. So many ways to mess it up that even lawyers mess it up a lot. And I'll be honest with you, I've seen some really poorly drafted ladybird deeds. I've seen some really poorly drafted quitclaim deeds that were done by lawyers. And the family that thought that they were doing fine, the lawyer probably thought they were doing fine, and it caused all kinds of litigation and dispute and arguments and everything else. And so the bottom line is this is, as much as it seems like it's a simple form to fill out, I did a whole presentation on this a few weeks ago about how easily it is to mess up your real estate by filling out a deed wrong. And, you know, literally having one or two words different can make all the difference in the world. Even the words husband and wife, you would think the words husband and wife are pretty explanatory. If you write it differently, if you write it wrong, if you don't put it on there at all, it has a major impact on how the deed is going to have, the legal effect the deed is going to have. I'm going to address one more issue when it comes to these ladybird deeds and quitclaim deeds, and that is the cabin. Let's say the up north property or the family property, right? So this is probably the most common thing that I see is that I'll have a potential client or a client come in and they want us to do estate planning for them. And we go through and we make sure we've covered their house and we make sure we've covered their bank account and their investments and their IRA and all of that. And then we get to the family cottage and I say, okay, well, do you have a deed for the family cottage? Well, no, I don't, because I actually own that with my 3 siblings. Okay, well, how do you own it with your 3 siblings? Well, I don't really know. Well, how did you get it? Well, when mom and dad died, we just got it. We own it now. They had done a quitclaim deed or a ladybird deed. Okay, here's where the problem comes now. How do you own that? Can you make sure your interest in that? So let's say you have a property on Higgins Lake. Mom and dad had a property on Higgins Lake. They bought it in 1950 for $30,000 and now it's worth $700,000. And you say, okay, I have this with my 2 siblings, so it's going to be 1/3. Well, that's 1/3 that if you don't have a mechanism to make sure that goes on to your family, that's a huge loss to your family that they're losing out. And so if we don't have a mechanism to do that, it's going to depend on how mom and dad wrote the deed. It's going to depend on whether or not we can get compliance from the others. So this is one of the most frequent things I do with families is that when they inherited property and they now have it with their siblings, I'm going to have a family meeting with all the siblings. I'm going to need to see that deed. I'm going to have to get some agreement between the 3 of them that they all agree that they want to pass their share on to their family. And it becomes this huge mess. We've had more family disputes about this type of thing where mom and dad were trying to do the best thing. They were trying to do the right thing. They leave it to all 3 of them. They do it through a quitclaim deed or a ladybird deed. And then 10 years after death, it causes all kinds of problem. And it's not even just a family dispute. It's a matter of how the deed transfers property. So for example, most of the time when that happens, I can't include your 1/3 share into your trust. I can't include your 1/3 share into your will. I have to get the consent of your brother and sister and have them change the nature of the deed and change the nature of ownership that they have in order for you to be able to pass that on through your will or your trust. So if the other family members don't find it convenient to meet with me, and they won't agree to rewriting that deed and redoing it, then it's a, you know, and this happens quite a bit, then that property may not get passed on to your spouse, may not get passed on to your kids. And honestly, more times than not, that is the case. But people, your siblings don't realize that. And so they think everything is fine until somebody dies. And then now it's too late, because now we're talking about how, even if they want to do the right thing, it's about gifting that property and the complications with gifting and other things. So when mom and dad intended to do the right thing and they saw, you know, their neighbor did this or Aunt Susie did this, and so they did a ady-bird deed or did a quick claim deed, and it transfers to all three kids. The kids decide to keep the property as a vacation property, and now we have all kinds of problems because you know, it's certainly not guaranteed that you're going to be able to pass on your share onto your family, and that requires a lot of negotiation, a lot of back and forth. And for them to even show up, they're saying, well, why do I need to meet with your attorney? I got my own attorney. Why do I need to meet with your attorney? You know, things like that. And so the bottom line is this causes all kinds of trouble because it's not detailed enough. It's not nuanced enough. Okay. So I liked this one here. This is such a common thing that I say, you know, when I go through some of my objections and some of my concerns, I'll have the parents say, well, no, you understand. I understand, Bob, why you're concerned about this, but my kids all get along. They're all going to be fine. There's not going to be any problem. So I like this little cartoon. It says, and I'm sure I can trust you not to fight over my money when I'm gone. This is a dad talking to his kids, and they're like, of course. And of course, they're all hiding little weapons, you know, an axe and a club and a mace, and you know, they're all getting ready to fight, but they're telling dad everything's going to be fine. I cannot tell you how many times that we've had that it surprised the heck out of me that it caused all kinds of family turmoil, all kinds of family grief that could have been resolved by just having a plan in place before dad dies, before mom and dad dies. Ideally, when they're both still living, so that we have a joint plan that everybody understands, and there's not room to fight, there's not room to argue, there's not room for bad feelings, because we already have that plan in place. Okay, particularly when it comes to the house or other things that have sort of an emotional attachment. All right, so let's see if we have any questions, and then we're going to give you a mechanism. Savannah's going to come back on. We're going to give you a mechanism of reaching out to us and asking one-on-one questions at no cost to you, and kind of interviewing us to see whether or not we're going to be a good option for you to update your planning and making sure that your house passes on appropriately. So Savannah, if you want to kind of weigh in and give them some instructions.
Yeah, of course. Thank you, Bob. And thanks for everyone for joining us today. As Bob mentioned, we do have a couple of easy ways for you to get in touch with our team. I'm actually putting in the chat box right now a link. This link you will click, it will take you to a calendar. You'll choose a day and a time when a member of our team can give you a call. Now, if you're ready to call now, you've got a question, I don't want to pick a day, I want to talk to somebody now, go ahead. I'm going to go ahead and put our phone number in the chat as well. It's 810-694-9000. We do have team members standing by that can answer base questions, general questions about our firm, about our process, and then possibly schedule your consultation with an attorney. So we would love to get you into our office if that's the best thing for you. So again, you can call us at 810-694-9000, or you can go ahead and click that link and it will take you to the calendar and you can choose when we will call you. You also will have an email coming to your email inbox any minute now that will also have the link and the phone number. And then tomorrow, I'll be sending another email with the replay from today's presentation. So be sure to share that with family, friends, or anyone who you think could benefit from hearing this today. Thanks again for joining us. It's always a pleasure, and we will see you next week.